I got that.
Any mention?
Please, Your Lordship, I beg to mention item number 71.
71.
Yes, Your Lordship. Pneumonia, Your Lordship.
Where's the other side? Where's the other side? You told them?
I could not inform them in.
Yes.
May I please, Your Lordship? Your Lordship, I beg to make a mention of item number 65, Your Lordship. I pray for 2 weeks' time, Your Lordship.
No objection, Your Lordship.
Why?
The conducting counsel is having some personal difficulty, Your Lordship.
You're here.
Your Lordship, he would be in a better position, Your Lordship.
Who? Mr. Moomin?
Yes, Your Lordship.
He's sick.
He's having some personal difficulty, Your Lordship.
Yes.
Highly obliged, Your Lordship.
May it please, Your Lordship. Lordship, I beg to mention item number 72, Lordship.
No objection, Your Lordship.
You're there in the case?
Yes, Your Lordship. I'm on behalf of Sanchita Anya.
Sanchita Anya.
Yes, Anya.
Master.
Yes.
Your Lordship, I'd like to mention item number 67 and 68.
On behalf of
On behalf of the petitioner, Your Lordship.
67, 68.
Yes, Your Lordship.
67. 67 is 68. You're for the.
I'm for in
You're for the-
67. I'm
you're for
from
the
the
appellant in
respondent.
67 I'm for the petitioner, Your Lordship.
67 is for the appellant,
Lordship.
not the petitioner. Yes. You have any objection?
No, Lordship.
Okay.
Highly obliged.
What is your name?
Yes, Mashallah.
Lordship, I beg to make a mention of item number 64, Your Lordship. I'm praying for 2 weeks' time, Your Lordship.
No objection.
Yes.
Obliged, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 74, my Lord.
All the material matters are gone then. Yes.
I am for the state, Lordship.
Yes.
Similar prayer for item number 66 and 75.
Why so many adjournments? Who? Holidays?
Lordship,
Yes. Yes.
Amen. Pray for.
May please, Lordship. Lordship, I beg to mention item 62. Lordship, I humbly pray for 2 weeks' time, Lordship.
No urgency.
Lordship, since
No
there is
urgency.
no reason, my Lord.
Yes.
Much less, Lordship.
Please, Your Lordship, I've informed them.
Yes.
Item number 71, Your Lordship. I'm praying for some.
You've taken
2
consent.
weeks' time.
70.
71, Your Lordship.
71. Okay.
Right.
Your Lordship, I beg to mention item number 77. I pray for 2 weeks.
Who's the other side? You have taken consent? No.
No, yeah,
Then you have to wait.
stay.
You have to wait. You have take consent. That is the norm. Yes. You don't take consent. How can you mention it? You tell them first, then you mention it. You look for them. Yes.
Item number 1.
Please, Lordship. This is a repetition, Lordship, whereby I am aggrieved by the action of Muda authorities.
Action of?
they suspended my building permission, Lordship, the Buddha authorities. Primarily, Lordship, there is a dispute between me and the respondent number 3, my neighbor, whereby it culminated into me filing an FIR. That FIR, my lord, has been transcribed into a 107 proceedings. Thereafter, my lord, an order has been passed by the
That means
executive.
a fight over boundary or something.
Lordship.
Then
Thereafter, Lordship, the executive magistrate has passed an order. Being aggrieved by that order, my lord, I'd prefer a criminal revision pending for court number 4, Lordship. Based on that, my lord, a complaint was filed by the private respondent number 3, who's my neighbor. May I kindly take a Lordship to
before Muda.
Lordship,
Let's
page
see
number
where's then.
46, Lordship.
You already obtained permission.
Lordship, permission is granted to me, Lordship.
Yes.
Page number 47, Lordship.
Yes.
Page number 47 is the
47.
application, Lordship.
This is given by whom?
This is given by the private respondent, Lordship. Their main contention, Lordship, is that there is a pending criminal revision. Therefore, my building permission must be suspended. And without a right to being heard or being able to show cause, my lord, such orders were passed by
Yes,
Buddha.
Mr.
My lord, I have to take
See,
instruction.
you already give him permission and you have just.
Yes, my lord, I will
Where's the
take
order? This is the between
46.
orders 47.
46, Lordship.
46.
10 December 2025, my lord.
Till the matter solved amicably.
Yes.
But my lord, I'm not, at this juncture, my lord, there has been no resolution because I prefer a criminal revision, but nothing pertains to dispute of
Have you
title.
appeared in the criminal revision matter?
Lordship, notice has been issued, Lordship.
Have you appeared? What stage is the criminal revision matter?
Pleadings are yet to be completed, Lordship. But my only grievance, Lordship,
You are
is
the
that,
person who filed criminal revision.
Lordship.
You want quashing.
No, Lordship, I'm aggrieved by the order of the executive.
What order is there in the from
Executive
the
magistrate, Lordship, who was of the opinion that,
drawing up 107 proceedings?
Lordship,
What's the opinion?
he said that
It's
matter
not a
has
question
been,
of title. It's a question only of breach of
Lordship.
Yes.
So that is why, Lordship, at this juncture, my license should not have been, my permission should not have been suspended, Lordship. And without a right to being heard, Lordship, it was arbitrarily suspended.
Now to hear 1/3, Mr. Kharkram, before any orders are passed.
Notice has to go, my lord.
Heard Mr. R. Kharkram, the head counsel with petitioner. Issue notice Mr. SD with MS. Ms. SD is present on behalf of
1 and 2, my lord.
Accept notice, no further notice on the 2 respondents. Notice issue respondent number 3.
Lordship, if also
Does AD written?
some interim prayer may be given, Lordship.
Interim prayer, what interim prayer now?
Well, just to
I
allow
don't
you,
know, we have still, you have to make a prima facie case, the things are fine, they have, but then if there's other collateral proceedings, want to know what is the stage, what has happened there. Suppose the other orders which,
well, that proceeding has nothing to do with my title, my lord. It's a criminal
no
revision.
question, but then there's a question of dispute over your boundary, over your,
Lordship,
that is the
if I
thing.
take a
So
lordship,
construction might have an adverse effect. Suppose you raise your construction and, you know,
my lord.
so let notice go first, let them appear.
Lordship, because at that criminal revision, the only point is that,
You haven't brought the criminal revision orders here also.
no, Lordship, but I've brought the order which have been aggrieved.
Where's the order? The criminal revision. Where you file criminal revision against. What pictures are these? Annexure 10?
This is the current situation, my lord. My building materials are just kept on my
No, this one,
property.
65.
65 is the private respondent, my lord. Private respondent, my lord, have also constructed a building without a building permission.
Are you related?
Yes, my lord.
You're related to the respondent number 3?
Yes.
How are you related?
The relatives, my lord, not siblings.
Relatives don't fight, yes. Where's that?
My lord, page 42, my lord.
Where's the order in the 107 matter?
Page 42, my lord.
Hmm.
Page 42, executive magistrate was of the opinion that matter has been settled amicably, but that is not
One
the.
second. Then why do you file revision against this?
Well, because I'm not. This report was not to my satisfactory. I also filed a petition, my lord, to withdraw this instant proceedings that was dismissed, my lord. Page 43.
No, it's been resolved since 22. Then what is the why did you come under this is 107 and 145, right?
Lordship.
So why do you come in revision against this order?
My lord, because there's certain grievance I'm not happy.
What grievance? You're making your own case bad. If there is recorded there's no encroachment, and then there's amicably settled. And why do you file it? It
Certain-
should end there.
Well, certain facts have not been taken into consideration, my lord. That's
What
why.
facts in the condition? Then you go by title suit.
But the only point is that we filed a criminal revision because certain aspects have not been taken, and learned magistrate said
See, it
that.
becomes very twisted, Mr. Harkrang. Your people also are funny. If the matter has been, if there's no encroachment and it's been settled, now they've closed the matter. Against us closing the matter, you've come to criminal revision.
Lordship, because certain facts have not been taken into consideration. My lord.
Yes, sir. Problem. Yes. Petition permitted to effect a personal notice also respond number 3. Stop. Praise been made for interim orders by the learned counsel petitioner. However, when perusing the same, it is noted that without the presence of respond number 3, it would not be possible to issue interim orders at this stage. Accordingly, this after 2 weeks for further orders and for consideration of the interim prayer. You cook your own goods. It was only amicably done. Anyway.
Item number 2.
Please, Your Lordship. Your Lordship, we praise for some more time, Your Lordship.
Why?
We have not received any instruction from the
Where's
department.
MS Pivarsaji?
She is in courtroom 1, I guess.
Where's Mr. Sen?
Lordship,
He's here.
he should be in the premises, Your Lordship.
He'll go on indefinitely as at admission hearing stage.
Pray for 2 weeks time, Your Lordship.
What do you need now?
That regarding the
The only question was for your counsel to obtain. The answer was here you're pursuing what is contra to what you're submitting for Delhi High Court. That's all. Correct.
Yes, Your Lordship.
Where is she?
She is in courtroom 1.
This matter has been repeatedly listed for admission hearing. Innumerable has been repeatedly listed. Accordingly, matter stands admitted for consideration and term order of any to continue further orders.
Hello, Lordship.
Item number
Then
3.
you would wait for the clarification with the side. Yes.
3.
Your Lordship, the respondent are supposed to file their place their objection.
Lord, I'm seeking some more time because first, speaker being quasi-judicial authority, my lord, first reply has to come from those who are contesting, my lord. So after they file reply, my lord, on legal issue, I'll file reply, my lord, only on legal.
Right. Otherwise, you don't need to file reply also. Yes.
Please, Your Lordship, I'm praying for 2 weeks' time.
You all pay cost then.
Lordship, just one opportunity. This is our first request.
Yes. What about your appeal for? Yes, dear number 2, your number 3, and then you're with Mr. Pandey. You're with Mr. Pandey. For number 4. And who's for 5? Collectively brief 4 and allowed for the 2 weeks time to file affidavits. Yes. This thereafter and so on.
Grateful, Lordship.
Much of it.
4.
Yes.
May please, Your Lordship. Lordship, we pray let this matter may be called up at the end of the board, Your Lordship.
What's it for today?
For
Well,
hearing, Your Lordship.
for that hearing on that 7-11 only. Your Lordships had heard us 1 year back, detailed arguments, but we failed to file the written synopsis, which is why this matter continues to come on board. This is that matter, Lordships will recollect that the allegation is there is some discrepancy between the election petition which has been filed before this court and the copy which has been served upon the respondents.
See, is it a curable defect under section 83?
I'm sorry. Yes, Melody.
See, we're talking about. I think, if I remember correctly, only about substantial compliance. It's not a question
yes,
of. It's not a question of section 81 or something,
yes,
right?
Yes. We had placed there are 2 constitutional bench judgments which cover this entire issue.
Who's appearing for you?
Mr. Pandey, Your Lordship.
Where's Mr. Pandey?
Still on legs in some court, Your Lordship.
Where?
Supreme Court, Your Lordship. At the end of the board, Your Lordship.
One thing, Mr. Paul, is your client interested in pursuing this matter?
Well, it's my instruction.
Because you might have a good case, but I think that the way things have gone, we disposed of an early election petition. It's just that without going to the merits of technicality, it was dismissed, which is very unfortunate.
Well,
yes.
However, Malaj, I would pray that this issue, my lords, may pass a judgment on this 7-11, my lords, because it would be, my lords, the kind of contentions that have been raised by both sides, my lords, and the law, the little effort that we've made to assist my lords, it would come as a, my lords, authoritative judgment on this issue.
See, the thing is that, Mr. Paul, if you can satisfy substantial compliance, then yes. If substantial compliance is not there, then election petition has to be thrown out.
Yes, if your lordships would recollect, Millets, in this matter, we have pointed out that the defects which they were alleging are not even there. Because what we had pointed out is, Millets, that it has to be compliance in substance. It does not need to be, Millets, an exact copy of what has been filed before this court.
No, that's why we talk about substantial compliance, which is curable. And if not substantial, then if it's substantial, then it's not curable.
Millets, may I pray your lordships have this matter on a fixed date?
When is the Pandey coming here?
Not sure,
Will be here today after tomorrow?
Not sure, Your Lordship.
Not sure. We'll dismiss your 7-11 petition.
Not sure.
Otherwise, we'll dismiss your 7-11 petition.
Let it come at the end of the board, Your Lordship.
No end of the board business.
That's my instruction, Your Lordship.
Yes, okay, we'll have it today's. When's today's 15th. Yeah, it'll be 21st, a fixed date.
21st, let's be on 21st.
Fixed matter. Enough, we've given enough latitude to these matters, they've just been kicked around.
27, Your Lordship.
21st. Yeah, you argue it, yes.
What's up?
Yes, accommodation has been sought on behalf of the respondents, applicants of petitioner 7-11 application for some for posting the matter later in the day. Court's not inclined to post it later in the day. Listed as a fixed matter on 21st. Yes.
Highly obliged.
Only that point will settle it.
Only that issue, Millets. Only that.
Item number 5.
Only, my lords, that this any judgment which would then fall from this, my lords, in this case, would, my lords, act as a template for all other issues, all other matters, my lords.
Hopefully, I'm equal to the task. It's always easier to dismiss.
May it please, Lordship.
Yes.
Lordship, I'm praying for withdrawal of this matter, Lordship, with liberty to file afresh.
After all the trouble taken.
Lordship, I understand, Lordship, but there are certain facts, Lordship, which we have missed out in our pleadings. So, Lordship,
Okay,
I'm praying.
no objection.
My lords, at this stage, withdrawing would be difficult because this is, my lords, revives after that review has been allowed.
Doesn't matter. Let them.
My lords, they can withdraw, but my lords, I will object to the liberty, my lords.
Yes. Yes, Mr. T. Dakha today has sought liberty, has prayed that the matter be allowed to withdraw the instrument application with liberty to file afresh to enable the. And there are certain other developments.
Yes,
which have
there are certain facts which we have missed out.
Mr. K. Paul on behalf of respondent.
Respondent 6, Your Worship.
And Mr. Marpan on behalf of 1 to 4.
1 to 4.
You object to the withdrawal.
No, my lords,
not objecting to the withdrawal of the writ petition. However, have raised reservations with regard to the liberty that may be granted. Court has heard the learned counsel of the parties. It is noted that this matter has since been revived by virtue of the review application. The review of the final order being allowed by order dated 12/3/2026. Though objections have been raised by the learned counsels for the respondents, however, as the matter concerns purely a point of law and interest of justice, the withdrawals allowed with liberty as prayed is.
Highly obliged.
My only prayer, my lords, might just hear me for a second on this issue. Since my lords are granting the liberty, your lordships would recollect in this matter, my lords, in the judgment, the original judgment that was passed by my lords, your lordships had categorically recorded that nothing survives in the matter, only because it has, my lords were under the impression, my lords, that it was required to be signed by 2 members, and the issue, my lords, that it was signed by the CM was not brought on record. That, my lords had allowed the writ petition. That subsequently, my lords, in the review have my lords recalled that order. Now, my lords, by virtue of a second round of litigation, what they'll essentially try and do is, my lords, canvass the entire case all over again.
No, that you have enough recourse. Yes, next matter.
Okay.
Yes.
Item number 6.
Please, Lordship, in view of the order 23/03/2026, this order where in compliance of that order, I filed an application to implead the respondent as a necessary party, Your Lordship.
Where's the respondent? Where's the miscase?
This miscase number 6, my lord, is registered.
My lords, the only thing is that in the writ petition, there's
a contempt.
Yes, contempt application. Where
contempt as far as because main grievance was against the education department. We have said that for regularization we have already moved the government. So from our side, my lord, there is no contempt. And as far as the number area of
who do you want to implement?
No, actually it's a personal department actually.
Okay.
So there is a order, Lordship. Yes.
Same submission we had last time.
Yes. Personal department is the main, but we have not made a party. This is the miscase to implead.
But the matter is pending before finance, my lord. Now they were not a party in the writ petition.
They seem to implead them now. There's an application for impleadment of the Secretary of the Government of Meghalaya Personal ARB Department stuff. Mr. Petitioner submits that the parties what we impleaded is necessary in view of the fact that the case for consideration of petitioner is lying with the said department.
Yes.
Mr. K.B. Varsaji, who was appearing for the other respondents in the main contempt application, has submitted that. You appear which department?
For the education department.
And
however, my lord,
education department, the file has since been sent.
To my instructions, my lord, it is not pending in the personal department.
Yes, it's not. That's the file affidavit.
Yes, my lord.
Yes, sir. You file affidavit here?
Yes, already
file affidavit.
Yes, yes.
So, no. On behalf of the education department, submits that there's no there's no where's your affidavit?
No, my affidavit was filed on 9/3/2026.
On behalf of the 2 respondents from the education department, submits that from the side of the 2 respondents, the order, the directions of this court have been complied with. The same is noted. Accordingly, in consideration of the prayer, the prayer so and so, case number 6 stands impleaded as respondent number
3.
Registry to make corrections. Miscase allowed disposed of. Yes.
Only thing that I have not received a copy of the miscase.
We have given on the last occasion only.
Yes, Mr.
We'll keep it.
Also entering appearance next on main case. We are doing praise for that 2 weeks time to file affidavit.
Let's Lordship.
Item number 7.
Yes, sir.
My lord, I've already filed my impleadment application.
Lordship, last time they have filed it today, or they have given another
Corrected
press
version.
copy,
Corrected
Lordship,
version.
because I was confused. So I may be given some more time to. Today only they have given another press copy of the petition. They have filed. They said that some mistake was there.
Yes, my lord.
So they have filed a press. I don't know, but
My lord, it's not on board. My lord, there's again the second corrected version.
What is this?
My lord, there's a
this
miscase.
is application for implement to JHDC. This is actually we have filed. Yes.
My lord, the correct version is still with the
It's not
registry.
correct form.
Yes, my lord. The correct version is with the registry, my lord. They just
You withdrew the earlier one.
yes, my lord.
You withdrawn it.
Yes, my lord. And my lord, I file a correct
No, this
version.
miss case number 34 has been withdrawn.
Yes, my lord, because it is. I have to place before you. It's the same. It's the same application, my lord. Just that it's in defects. It was wrong.
They have not
They are
withdrawn,
checking it,
lordship.
my lord.
They have
My
to
lord,
withdraw
they-
today.
Yes, take down first miss case 34 MSOI Bank. Please that she may be allowed to bring a new application and also please be allowed to withdraw the instant miss case 34 2020. Withdraw, you're drawing this one when you say praise allowed, yes.
And my lord, we have filed a fresh one, but let it come on board. Let it come on board.
It will come. It will be registered later.
For the orders.
Number 8.
Must finish, lordship.
Miss case are withdrawn.
8.
Withdrawn. Main case list for the orders.
Please, Lordships.
Your Lordship, number 8 to number 50 is similar matter.
Yes.
And I'm hearing we will file the power today, Your Lordship.
You are paying for whom?
For 7 respondents, 7 acting CM.
What is this matter about?
These are the trading license matters.
Trading license. Acting CM of Sora.
Who appeared earlier?
Lordship.
Who was appearing earlier?
Earlier is yes.
For the CM of Sora, my lord, learned senior counsel Mr. Mahanta was appearing,
Mahanta.
but since
Now he
the
died.
CM has since deceased.
Who died?
The
CM.
CM died. Now
acting
you are appearing.
for
Mr.
acting.
Manta, what this court wants to know is whether Mr. Manta will be appearing now for the acting CM.
Yes, Your
You
Lordship.
say that, and you are appearing for? And Ms. Jangreso?
The respondent counsel.
Okay. Right.
Same of Miriam is not the party in this case.
Same William?
Miriam is not the same of Sora is not the party.
In the miss case?
In the miss case, madam. Can you see Piru's
No,
application?
CM of Sora was a party represented by Mr. Mahanta. Thereafter, we have filed.
This is a miss case.
Lordship, yes.
Series of miss cases started from.
Okay, yes.
For impleadment of the acting CM, Lordship. And my learned senior is appearing. Already impleaded on the last level.
It's one number 7.
Yeah, respondent.
7 is the acting CM, my lord.
Yes, 7. You are appearing for 7. That means confusing. Yes.
6 was the
you want to file objections? Or what do you want to do?
We'll file the power today.
Okay. Mr. L.M. Sangma, learned counsel, submits that on behalf of the newly impleaded respondent number 7,
Acting
that is
CM.
acting CMs or a CMship, they're entering appearance today itself and will be filing the requisite power stuff. And what do you want, Mr. Changreso?
Maybe for listing the matter, admission hearing.
Yes, Mr. Changreso, senior counsel with so-and-so, appearing for the respondents 1, 2 and 3. And you're appearing for whom?
1 to 4.
And for side, praise matter will be listed for you. Already filed your affidavit. You haven't filed your affidavit. You already filed yours.
No, it's not requirement.
Yes.
Lordship.
The matter will be listed for admission hearing. Yes. Just after 2 weeks. Mr. So-and-so prays that he may be allowed to file affidavit in the meanwhile. Praise God. Yes. File once enough. Same question. Interim orders, any interim orders here? No.
Lordship, no.
Yes.
Wait, please, Lordship. Lordship, on behalf of respondent 6, I'll file my affidavit in the course of the day, Lord.
Where's the petitioner? None appears as a petitioner. The states file affidavit. Where's Abraham?
And for respondent number 4, Your Lordship.
1, 2, 3, you filed.
Mr. Lordship.
Have you filed affidavit, Mr. Abraham?
51.
50 years, I filed yes or Lordship.
Please, Lordship, this matter is since last year, Lordship.
The file goes through the day.
Your Lordship, I pray for
Respondent number
some time,
5,
Your
number
Lordship, to file the affidavit. I pray for some time, Your Lordship, to
No
file
more
the
time. Yes, for number 6.
Number 4, Your
number
Lordship.
GCDC.
No, Lordship. These are teachers, my lord, from Garo Hills.
Enough time. When
Today is the 5th time, Lordship.
5th time?
Yes.
You're not filing rejoinder?
No, Lordship.
You won't file rejoinder to the state affidavit?
In regard to private respondents, I will file rejoinder, Lordship.
Your Lordship, I kindly pray for 2 weeks, Your Lordship.
I have to go through, Lordship.
5 is filed. The Marak filed for 5 years.
6 I'll file today.
6 you filed today. So 4 you're not filing anymore.
I pray for 2 weeks, Your Lordship.
What you give?
Last chance maybe, Lordship.
Last chance, okay. Mr. S. Deb, council number 6, submits that the affidavit will be filed in the course of the day. However, MSN Lamare for number 4 pays for further 2 weeks' time. Although the matter has been long pending in terms of justice, 2 weeks for the time slot for the respondent number 4. This after 2 weeks for a joint evidence to the other affidavits.
Much Lordship.
52. Sorry. My lord, I have not filed my counter affidavit yet. I'm still waiting for instructions. I need a last chance, my lord.
Who's the person responsible to give instructions?
My lord, is the law officer who was hospitalized, sir. He's back, my lord. He's back on service, but it's just that, my lord, he could not give me on time. He could not give me instructions on time. Both for 52 and 53, my lord. They're not connected matters, but...
As paid for the 2 weeks time allowed. Affidavit, yes.
53?
The next date, the affidavit should be on.
Yes, my lord.
53?
Same order.
Same. Most obliged, my lord.
54?
53.
Sir, I've asked time. I've asked time, sir.
Okay.
Yes. I'm sorry.
54?
May it please your lordship. Your lordship, I pray for 2 weeks' time, your lordship, to file the affidavit.
The same motion matter?
No, different. Here, my lord, we are challenging the issuance of patta, my lord, by GHDC.
Same parties. The earlier motion today.
Same. I'll have to take instruction.
The habitual litigants.
Pardon?
The habitual litigants.
I'll have to take instruction.
You have to take instruction whether the habitual litigants or not.
That I'll have to.
Yes. Your final course of the day.
Okay, final course.
So last one, yeah. For 5 to 8. So that after the final course of the day. Ms. Anamari for
1 to 4.
Vice
It's the third occasion, my lord, they are seeking for time. Yes. So
for a 2 weeks time. It's expected next date after it be on board.
Highly obliged.
Start inflicting cost, then maybe I will come faster.
Obliged.
Yes.
55?
Please, Lordship, this matter was sent for mediation. It was not settled there.
Not settled.
Lordship, we will need some time, you know.
You have to file affidavit?
Lordship, yes.
Yes, matter returned mediation. Matter has returned back from mediation proceedings being successful. With any friend AG praise funds allowed.
Let it be 3 weeks time, your lordship.
Please send an affidavit this thereafter.
56?
The affidavit is still awaited from the respondent, but
where's the respondent?
This is the 5th time that they would be seeking, if at all they are taking time today.
What's the matter about?
This concerns the election to the VEC of a particular village.
Parties here also?
They have been served, but they fail to be represented, Malad.
Yes, from the state there's no one. This is really disconcerting. Yes. Yes. Kiwi Varasarji, S. Sham. Then KP Varasarji, where is he? He was here just now.
It's not, I have not seen him.
He was here just
He was here.
just a fraction of a second earlier.
I don't know whether if it will be fine.
No.
Some kind of Mr. Paul, you are appearing here?
No, sir.
No, well, I am in the next matter.
Well, come after 2 weeks, then your lordship. I do not have the brief, so.
How much time can the court grant? No one is appearing, bothering appearing also.
It's very unfortunate, your lord.
I'm sorry, my lord, we will take.
After 2 weeks, your lordship.
Just after 2 weeks, yes.
Let it be a last chance, my lord, considering the fact that it pertains to election, my lord.
You all have suffered same disease also, Papa.
7.
We wait in 1 month.
57.
Lordship, in this matter also will need some time, your lordship, to file the affidavit.
These are those matters concerning those teachers.
No.
I'm sorry, I'm sorry. My apologies.
We'll need some time, your lordship.
No, one second. Who's number 2? Petitioner number 2?
No, lordship, I'll file my application for deletion.
Where?
The name of the
Filed it?
petition. Yeah, I'll file it in the course of the day, lordship.
You have not filed it. This is the editionless matter.
Yes, lordship.
Yes, Mr. G.M. Sangma. We are appearing for other petitioners, but are you appearing for other petitioners?
Yes, lordship.
All the other petitioners?
Yes, lordship.
Mr. G.M. Sangma, counsel for the petitioner submits that the application for strike for deletion of petition number 2 will be filed in the course of the day. 11 and 13 also have also resigned.
Yes, lordship.
Yes. So, Mr. Indishwala, our next paragraph, our praise for. What about you're appearing for whom? You file affidavit. Already filed it. Mr. Indishwala for respondent 126 at AG and Mr. Nemes R. Datta for 7 to 10 and 12. Pray for or further to extend the file affidavit. Let's get after
58.
Your lordship, in this matter, I'm asked for some accommodation, your lordship.
You have objection?
No, your lordship. Short date,
Any
your
other
lordship.
objection? Yes.
Construction.
Yes.
This is for appointment to arbitrator, my lord.
Will appoint?
No, your lordship.
Justice Wi-Fi may be appointed, my lord.
Your lordship, please,
Justice
kind
Video.
accommodation. My seniors.
Who's the senior?
Miss P.D. Vijay Baram, your lordship.
You inform her.
No, but your lordship,
That
please,
the court-
just a short date, your lordship.
They're taking
It's your kind indulgence,
in
your
the hands of
lordship.
the consuls.
No, please, your lordship, because my seniors handling the case. Short date, either by
The
Monday.
case is very well and good.
It was listed on, they took adjournment that day also, 10th night.
Yes.
Today's.
What is the claim? What is the amount?
Amount is not mentioned, my lord, but the contract value is.
What is how much?
Claim roughly, my lord, page 20 will show.
22 crores.
22 crores, your lordship, approximately.
So Justice Wi-Fi or Justice B.D. Agarwal, any of them.
Your lordship, I asked for some time, just a short date, your lordship. Either by Monday, your lordship. My senior will appear.
You tell your senior that the court's already directed for appointment of a retired judge.
Your lordship,
That's not up to the parties to
Your
consent
lordship,
or to
just kind of by Friday, your lordship, if it's possible.
list on Saturday
Please, your lordship.
But Saturday have some.
or Friday.
Friday. Much obliged, your lordship.
Yes. On the prayer of Marshal Long.
Yes, your lordship.
Yes, due to absence of a senior in council, this is a matter on Friday.
59.
And my lord, we will be filing the so-called during the course of
It
the day,
appears,
my lord.
it appears an order has been passed by the collector, Your Lordship. The collector has not really gone into the issue, which is required to be determined.
Collector has very limited jurisdiction, my lord. If your lordship will kindly see.
He's not deciding. See, Mr. Advocate General, it's not a question of deciding fact. It's a question of seeing whether the person is a person interested at all. That's the only thing.
Yes, my lord.
Then the adjudication will be limited to that.
Yes.
Now see what objections raised by this person. Just listen.
Yes.
His record. The land Muktapur, measuring approximately 26 square kilometers, is ancestral property of his clan when the Jaintia kingdom was based in Jaintiapur and the land falls under control. See,
yes,
locals in the 8 village area settled permission granted from his clan. In 935, or passing his grand uncle succession matter going to be settled until now. The documents, the counterparts have used. Can such objection be entertained?
I understand. No, only issue if you lordship will see that the deputy commissioner.
The deputy commissioner, in his wisdom, can't understand. Now, I will one day say that, I suppose some acquisition, I'll say, fine, the land all around this Taj Mahal is mine.
You can't refer it to.
It's not a question of title, it's a question of whether it's a person interested or not.
No, only problem because there was some confusion in his mind. If your lordship will kindly see page 69 of the order, my lord. That is the problem with page 69 of the contempt petition, my lord.
Page
69 of the contempt petition, my lord. Where your lordship has issued direction to him. Page 69, your lordship has after referring to section 15, my lord, at page 70, my lord.
Yes.
Notification was issued, but the objection of respondent number 3, it is seen that was filed before was issued, but the same was entertained. And instead of adopting procedure laid down law, collector has instead recorded that both parties requested 1 month. This, to the mind of the court, is unsustainable. Accordingly, impugn order proceeding as far as it relates to the direction or agreement to arrive is set aside. The collector is therefore required to examine the maintainability and objection of locus as and pass necessary order in terms of section 15 of 2013.
Right.
Section 15, Lord, if your lordship will kindly see the previous page 69, Lord, kindly see previous page 69.
Yes.
But the collector has jurisdiction to only go into 3 issues, my lord. Area and suitability of land proposed, justification offered for public purpose, finding of social impact assessment. Only on these 3 issues the collector has jurisdiction, my lord. Beyond that, it is beyond only under 64, my lord, section 64 of the Act. The collector can the adjudicating officer, the special officer under the Act can decide. And if you
then do it under 64.
Lordship, at para 2 of the order, Lordship, notwithstanding with section 15, your lordship, the collector has gone into the issue and he has passed this order. Notwithstanding section 15, and even otherwise, this order which your lordship has passed, this order has not been challenged by the respondent, if they really agree by this.
Yes, we are accepting.
Each to your lordship, he has not even, notwithstanding section 15, your lordship, he has decided the issue.
Yeah.
But with regard to the maintainability, the objection, the locus, that has not gone into by the collector, lordship.
Locus, section 15 says any person, my lord. That is the problem. Section 15, if your lordship will say 69, any person interested in any land, my lord. Even I can go and object. That is the remit of section 15, my lord. That is the difficulty. Any person interested in any land, my lord.
Same thing,
And only
Mr. Advocate General, I think that he is the collector of that area. He is supposed to know. He has to be subject to satisfaction on the documents that have been produced. Now you can't say on any documentation anything. One person comes and says, "I'm Raja Bhoj of some so like you entertain his objections."
Understand? And so if you
is that the story we read when we were children? In one of the English subjects.
Unnecessarily getting stuck in the court before a special court.
Yes, some Raja Bhoja or something. He's like, he's imagining himself to be the emperor, like Maharaj the Raja of, So then he's going to subjects and extract revenue. Same thing. Can a sensible officer be swayed by this?
No, lordship, that
Page 81, your lordship, the petition has also not been signed by the objector, your lordship. Even the documents are unsigned and all.
No,
the necessity of the documents have not been gone into by the collector.
Submits that hearing objection has since been conducted, and as per the instructions, the Deputy Commissioner, West Janti Hills, has complied with the order of the High of this court and has not gone into I will have to what this is started directed to find affidavit, bring the order on record. Let them bring it on record. Absurd, really.
We will file the affidavit is ready, my lord. We'll place it on record.
60.
Please, my lords.
Will come on 24th.
Malaz, this is that matter, Malaz, where I was mentioning concerning those teachers, and Malaz, we have a very limited prayer in this. We were only praying.
Will come on 24th along with other writ petition, your lordship.
So is it different from the others?
Same lordship. Same.
This Malaz, there's a difference in so far as Malaz there, my learned friend Mr. Shulai had objected because there was that withdrawal and liberty. Here, that withdrawal and liberty is not there, Malaz.
They'll come on 24 along with the other cases, your lordship.
So, this first time has come, correct?
Lord, second time.
Second time.
After motion, Mr. Industrial and AAG, assisted by Mr. Khan, submits that as the matters connected to other petitions that are pending
Lordship,
on the same issue, which are fixed on 24th. The instant matter be tagged
Lordship.
together.
So 24th.
All is a council, another with so and so does not object. It's on 24th.
Oblige, your lord.
61.
As for instructions and affidavit, I'm praying for some more time.
When was it filed?
It's the first time after motion, second affidavit.
You already joined?
No.
Any posting?
No, this is here, the petitioner, my lord, took maternity leave in the year 2024.
No, but have you decided representations again? Because the interim order operating in their favor. But if she's been released, she's been released. What's the situation now?
My lord,
regarding the release, I have no instructions on that, lordship.
Has she been released? Has she left the station?
I don't have instructions on that, lordship.
No, my lord, she went on leave in 2024, my lord.
No, she's been released now totally?
No, not yet, my lord.
She's still here in station?
She's not in service, she's at home, my lord.
Manipur, whatever. Huh? When you file affidavit, then
we'll file affidavit.
Dr. and Muzika, please sponsor for a 2 weeks time for affidavit.
Interim order may continue, lordship.
Interim order may need to continue. Yes, until next day.
Hearing 63.
Yes, Lordship. Lordship, this is with regards to the payment of some.
Yes.
Some ideas, Lordship. As per the last.
Lordship, with regard to that sanction in 2025, my lord, we are yet to receive any communication.
It's miscalculation.
Lordship, because
there is no miscalculation here, Lordship.
You will say that, he'll say a different.
Yes.
What will happen? You get more money, there'll be no miscalculation.
Lordship would see
you will
the
get less, there'll be miscalculation.
If Lordship would see the writ petition, my lord. Writ petition has been filed. If I may, my lord.
Yes.
Writ petition has been filed stating that the petitioner has taken VRS and she has not got her pending salary from 2017 to 21, and there is no document, my lord, appended in the writ petition apart from the release order. Now, my lord, we have filed an affidavit, we have sought instructions, and it appears that firstly she has resigned.
No, we only
Secondly,
we concerned with an office order.
Lordship,
2625.
Lordship, yes, that appears to be, my lord,
we get 5,42,000, which concerns revised areas.
Yes, this has come
now
separately.
she's already been paid till 22
as a one-time settlement.
Yeah, one-time settlement.
Now this is nowhere.
Now last time, Mr. Sangma said that since this order is there, passed out of the hand of secretary of the executive committee, give me the money.
Lordship, in my rejoinder, I have very clearly stated regarding the payment of 3,22,340 rupees, because I have very clearly stated actually my amount was actually I supposed to get it the entire amount 13,28,053. But then out of this one now they have calculated, maybe there is a miscalculation, but they have admitted out of this 13,28,000. I have admitted, it is very clearly stated before this on oath. We have received, well, my learned friend in his affidavit, he has stated that 3,22,000, 340 rupees. That is, they saying that is the amount have paid. I have no quarrel with that. I have received it. But
who has a quarrel with that? Nobody has a quarrel.
Yes,
with that.
now they are saying that
now the only thing you say, if I understand correctly, that there was an order whereby you to get 5,42,000.
Yes.
So they will take instructions on
Yes,
that.
Lordship.
Now Mr. Deb has said it's a miscalculation. That's all.
Yes, Lordship. So,
you have to show that how it's been miscalculated.
Yes, Lordship.
If miscalculated, then you won't get the amount. If they can't show how it's miscalculated, then you'll get the amount.
Yes, and this husband, that instruction, same instruction, I think is husband from on 16th June, 16/6/2025. Same instruction they have received on the order dated, Lordship. This is the second time, Lordship.
Yes, Mr. Dem.
My Lord, if my Lord may kindly produce the affidavit that we have filed, my Lord may kindly see para 5 of the affidavit, my Lord. Page 4 of my affidavit. My Lord, may kindly consider this, that the statement made in para 3 of the writ petition.
No, Mr. Dale, we know we've already seen this. What about this order?
No, this is the order. This is the order that she has produced. This is neither a part of this writ proceeding. He brought from somewhere this order. He brought from somewhere from this order, my Lord. Neither now. No, the affidavit. Just a minute.
Why you receive instruction?
Yes.
Where does this come from? That's all.
Yes. No, we are yet to.
The matter.
Yes, we are yet to receive the instruction. But the fact is this, my Lord. Now, this, if this was the calculation,
it has an office order number. 40 something. It's got a memo number also.
Yes,
you only
yes.
have to take instructions.
I will take instruction.
Have you taken?
No, I will take instruction. We have written to them, my Lord. We are yet to receive the instruction.
Mr. S. Day has not been able to come instructions with regard to the letter order of office order number 42 dated 2/6/2025.
We have already written to them on 16 June 2025, but till now we have not received.
The next date specific instruction will be obtained. Yes, after 2 weeks.
My Lord.
Much less logic.
69.
Stand on the alarm.
Much less logic.
No, this is a contempt against the order passed by this honorable court, my Lord, which was passed on 1st July 2025, my Lord. Page 56, man.
You were the appellant there?
No, I would say respondent. The respondent was the appellant. They have come against the injunction order which was set aside. If your lordship come to, if your lordship para 5, my lord. It's a status quo order, my lord, in respect of the suit land.
Yes.
In spite of the status quo order, my lord,
they broke the status quo.
My lord,
by doing
that's
what?
our contention, my lord. They have, if your lordship come to page 5 of my petition, paragraph 12, my lord, I've mentioned how the status quo was violated, my lord.
Yes. Yes.
Paragraph 12. My lord, firstly, on 2nd July, after the order was passed on 1st July 20, well, I'll just give the background of this case. Man. Suit was filed by the respondent. Ad interim injunction was given to them by the trial court. Then subsequently, we filed an application for vacating the order. That was made absolute. Against that order, we had preferred a civil appeal before the judge, this council court, my lord. So the injunction order, the absolute injunction order, was set aside by the appellate court on the ground that the respondent themselves have admitted that they are not in possession of the suit land, my lord. So against that order, they have come before this Honorable Court, and this order has been passed. This status quo order has been passed on 1st July 2025, my lord. So on record, it is an admitted fact that they were not in possession of the suit land. That's why the injunction order, which was made absolute, was set aside by the appellate court, my lord. So, my lord, what had happened is that after the order has been passed on 1st July, on 2nd July 2025, my lord, one person, if your lordship come to the second paragraph of paragraph 12. Firstly, on 2nd July 2025, the petitioner visited the suit land to check with the progress of the ongoing work. An individual by the name of so-and-so came to the suit land with an intention to work on it. Upon inquiry by the petitioner, he informed her that he has come to work on the suit land under the instruction of the respondent, and on being confronted, he left the suit land. In response thereof, the petitioner then immediately filed an FIR before the officer in charge, Mount India Outpost. This was the first instance, my lord. The second instance was on 7th July 2025, my lord. The nephew of the petitioner, while assisting with the construction work over the suit land, received a call from an unknown number, and on answering the same, one lady introduced herself to be the daughter of the respondent. Pursuing her studies outside Meghalaya, she immediately directed the nephew of the petitioner to stop the ongoing construction work and to vacate the suit land, failing which she had threatened that she will lodge a complaint before the police. In the event he fails to comply with the direction, the nephew of the petitioner did not pay any heed to the veiled threat given by the petitioner of the daughter of the respondent, and continued to carry on with the construction work in the suit land, and the same has all along been in possession of the petitioner. An FIR to this effect was filed by the nephew of the petitioner on the same day before the officer in charge outposts in this regard. Finally, on 8th July, that is at page 6, my lord, 8th July 2025, while the construction was in progress, the respondent, along with her daughter and the associates of 10 to 11 men, came to the suit land, threatened the lessee. Because a lease was executed between the petitioner and one of the resident of the village. So they had come, they have stopped the progress of the work, my lord. So these are all the incident by which the
suit land is the land which is constructing.
Then
the status quo over there, then you're not supposed to do anything.
My lord, we have been all along been in possession of the suit land, working on it, my lord. This is a temporary sheds which has been constructed by us, my lord.
Yeah, Mr. Hassan, you're objecting to the construction.
My lord, kindly come to...
You admit that you're never in possession of the suit land?
No, my lord, we never admit that we're never in possession. In fact, we are in possession, my lord.
How was it submitted that because you admitted you're not in possession, that's why the absolute injunction order was
set aside?
When the trial court issued granted ad interim injunction in my favor, from that time I've been in possession of the land. When the ad interim injunction was made absolute on 3rd October 2016, that also the suit land is in my possession. So your lordship, they have went on appeal. Then by order dated 5 July 2024, they have the appellate court has set aside, has quashed and set aside the
order of injunction.
Order of injunction.
Absolute injunction, yes.
So my lord, immediately I have come before this court. Then this honorable court on 20th September 2024 has granted a status quo order within the suit land. So after this honorable court granted the status quo order, that time also I have been in possession, my lord. I have cultivating crops within the suit land. So my lord, what happened is that when this honorable court passed the order 1st July 2025, then on 2nd July 2025 they filed an FIR against me because one of my helper has went and checked the crops of the land within the suit land. So my lord, my crops there have been lying there for 3-4 months. I've enclosed the photographs, my lord, in the affidavit. So my lord, and the construction, if you can see from paragraph 13 of their contempt petition, my lord, they have stated that despite the complaints filed by the petitioner and her nephew on receipt of the judgment on order dated 1/7/2025, the investigating officer directed the petitioner to stop the progress of work upon the suit land. My lord, the police knew it very well because 3 FIR has been filed against me.
What stage is the suit now?
Framing of issues, my lord.
It's filed 2014.
No,
there's no framing of issues now.
Yes, my lord.
Well, as far as the possession is concerned, that your lordship will find at page 44 of the judgment.
Status quo is a very fluid kind of situation. We see, unless there's concrete material to order injunction or to restrain any party, status quo is resorted to. Now, in this case, up to the parties also, since you agreed before this court also that you will maintain status quo. Status quo means don't change the nature of the suit land.
Yes, my lord.
That is what it means.
The police didn't stop
me,
me,
my
my
lord.
lord.
Raise structures, that means you're trying to change. Then you're creating, another ancillary kind of cause of action. So, like, if status quo to maintain, then you can't construct or do anything to that.
My lord, we have
Notwithstanding the possession, doesn't mean the status quo as to possession. Status quo is status quo.
Well, as far as possession is concerned, your lordship will kindly see at page 44. My lord. This is the appellate court's order, my lord.
But then we sitting here, we can't.
Is this on the basis of that the admission, page 44, my lord? If your lordship see the last paragraph, the subject matter of the appeal is in relation to the matter of temporary injunction. Further, while deciding the subject matter, prim facie possession is primary importance and documents are secondary importance. Moreover, at this stage, the issue of legality of the documents is not to be decided factor for injunction, as the same has to be decided through evidence. From the material available on record, I am hereby convinced that as soon as the suit land,
if there was, what do you call it, positive findings, then they should have. Then the order should have been to restrain them from interfering with possession, not status quo order. This status quo order passed by appellate court also.
No, my lord. The order was the injunction order, which was set aside, my lord.
Yes. In light of offense, if impugn order passed also is quite set aside.
Yes, my lord.
Right. So it says that send one condition on favor of the respondent, furthermore, appellant shall subpoena and the vacated shall be dispossessed from the land usually enjoyed. So now what happened was the injunction was vacated and it's final, correct? Now, against this order,
yes,
you came here.
Yeah, I've come.
And the status quo was passed. Then you should have agreed then to status quo.
My lord, kindly see.
My lord, the police didn't stop me. In fact, they stopped the petitioner, my lord.
They stopped him because they're raising construction. You're not doing anything.
Yes,
but the thing is that if possession is, as the finding is here, right? 44.
Page 45, my lord.
What do you have to say to this?
It's on the basis of that the injunction order was set aside and quashed. If your lordship comes on 3, 4, 5, 6, 7, at 6, line 6, the possession of the suit land has been admitted by none other than the respondent, as she admitted at paragraph 7 of the plaint, where she found that the land was fenced and boundaries pillars were constructed. Now the question arose whether it is for the respondent to grant temporary injunction when she is not in possession of the land. Applicable for the respondent, the plaintiff, because they are the plaintiff.
That's why, my lord, we have agreed
on the basis of this admission at paragraph 7 that the learned appellate court has set aside the injunction order, set aside and quashed the injunction order.
Then you'll have to resort to review. That's what won't help you. Well, see, the possession, there's a clear finding here.
Yes.
Then you're never in possession.
My lord, actually, we have come.
And a contempt, we can't pass directions.
Yes,
as such. You take instructions, otherwise, if the finding is there, you should have, at the time of disposal of the Mrs. appeal, you should have brought this attention to the court instead of agreeing to status quo.
Well, that's why we have agreed to that.
Because, my lord, status quo has granted, because here, my lord, we have come before this court, aggrieved by the order passed by the appellate court, my lord. I mean, the civil appeal, my lord.
Yes. Status quo will be on that day.
Yes,
on the day when the order was passed, on that day, who was in possession?
We are in possession. That's why
that's the problem. He's saying we, you also we.
No, that's why, my lord, the order is very, very clear, my lord. The appellate court order is very clear.
Should have been argued that way.
My lord.
And you take instructions, otherwise, now nothing's going on the land.
No, my lord, we have been stopped by the police, that's why, my lord.
Yes. You take instruction. And if the clear finding is there of the lower appellate court that you never in possession, you admitted before that court. In contempt, we can't pass directions. Also come the reviewer. Yes. On the prayer of the parties, let the matter appear for 2 weeks in the obtain instruction. Obliged.
70.
Passing all in contempt is futile also.
Yes.
Yes.
Lordship, in this matter, I'm praying for some accommodation on behalf of Mr. Shulai.
Mr. Shulai?
He's on legs, Lordship. Praying if the matter may be passed over to for the day.
No, no, this reason is not required here because this is a covert case, my lord. This is the Home Guard matters.
1 week. Same Home Guard matter?
Home Guards matter. Because she's the one left out. Yes, because he died in 2020, Lordship. She's the wife of the wife.
73. 73.
Here I'll record, take some instructions. This is with regard to VRS of the radio register. Kindly grant me 2 more weeks time.
No, any other radiologist available?
Well, they are saying there are only 2 radios in the entire.
And only thing is that whether alternative arrangements can be made. You can't make alternative arrangements.
Well,
where are you posted?
We've written to them. They've not.
Sukhoi or Dimapur, Nagaland.
Yes, Sukhoi is a composite hospital there, and then here in Shillong. How many multi-specialty hospitals are there? And Assam Rifles.
Yes, Lordship.
How many multi-specialty hospitals are there? Where
Only one in general, and 2 are actually ad hoc, Your Lordship. Along with that. Only 1 hospital is there.
Mantri Pukri, Sukhoi and Shillong.
1 in Dimapur. So how many radiologists in all?
2
appointed all these hospitals.
As per the affidavit, 2 only there.
In all 3 hospitals? Yes. They have a right to refuse your.
But post is there. They are not going to recruit, Your Lordship. That is the thing.
Post is there.
Post is there. Sanction post is there, but they are not going to recruit fresh since long. The medical board already.
That is a different aspect.
Aspect is that actually whether.
So you've served. When did you apply for VRS?
VRS. First I applied, Your Lordship, in 2024, 19 December, Your Lordship. 19 December 2024, my lord. Annexure 1, page 18, my lord.
See, Mr. Chaudhary, there's nothing to decide on in law anymore in this matter. It's only if they're willing to release you, but they have a right not to release you also. And considering their armed forces, they don't have radiologists, what they do?
But thing is that area is too much, Your Lordship. I have served also. It is to be considered.
Yes.
My exigence is also there. Otherwise, I would not have come.
In fact, the instruction is that they have taken up the matter with the ministry also, my lord. ATG Medical. To send on deputation from some other paramilitary forces.
Exactly.
They are saying the other paramilitary forces, there is a acute shortage of radiologists.
You can't recruit from the open market. So many radiologists looking for jobs. Today also Dr. N. Mozika submits that he has no specific instructions as to whether alternative arrangements have been made, inasmuch as in the other parliamentary organizations there is a shortage of radiologists.
We have sought for deputation from, but that is also been.
You won't record that. What to do?
We used to wait only when we can submit a fresh representation. The department will do something.
Fresh representation gives you time again to process it for another 1 year, you see. They come to court because of non-consideration. Yes, so it's expected that the respondents possibly consider the case of petitioner before the next date. Yes, just after 3 weeks.
I look.
76. 76.
Sir, we both the
Please, Your Lordship, we just pray this matter be taken up after 2 weeks, my lord, for hearing.
Why?
I have some difficulty. I have not been able to prepare this matter today, my lord. 29th.
You on holiday?
Lordship.
Complexion is changed.
Yeah?
Complexion is changed for us.
Complexion of the case won't change. Complexion of the council might change. Yes, on the prayer of Mr. S. and the personal difficulty, it's a matter of 2 weeks.
But
77.
Yes.
Your Lordship, in this matter, I'm praying for 2 weeks' time.
Who's your leading counsel?
As ADCM.
Why was it? Nokma matter or no?
No, no, Your Honor. Oh, Your Lordship, it's regularization matter.
You have no objection?
I have no objections, Lord.
Yes, on the prayer. Also, this is a matter for 2 weeks. That's it.
Grateful.
Item number 1.
We have state has filed 2 status report, one in MCPIL, my lord, and in other is in the main matter.
Why couldn't you file it at least 1 or 2 days before that? Give us some time to, to.
Yes, my lord. Yes, my lord. That we got the data yesterday night only, my lord.
It's very difficult because we won't have time also. There's no amicus here.
Yes,
the thing is that if we have to see, we have to, we have to read it also.
Yes, my lord. Yes, your lordship may have it next week, my lord. In fact, we got the data in these 2 holidays only, and we have compiled and prepared and got it filed because of an SIT report data came by mail yesterday night only, my lord. That your lordship, I'll file SIT report also. That report has also not been placed, my lord, because MCPI, your lordship may have it after a week, my lord.
We'll have it on. Today is the 15th. We'll have it on 1. 28 now, huh? 27th.
27th, my lord. 27th, my lord.
Yes, just take down. Take down. The 37th interim report has been filed by the Justice PT BP Patuki committee. The same is taken on record. Stop. Status report in this report in the main PIL. Main PIL number 2, 2022. Status report has just been filed today itself. Stop. Due to the paucity of time to examine the same, let this matter be listed on 27th April 2026. Miss case number 4. This dismiss case together with the main PIL on the next date. Stop. As it has been submitted by the Learned Advocate General that SIT report since been received, the same also may be placed on record before the next date. Yes, before the next date. Please give us the time to examine.
In MCPIL also, my lord. In MCPIL, the status report has been filed separately, my lord.
Yeah, okay. So MCPIL status report pursuant to order dated 5/3/2026 has also been filed about this case. No? After that follows the as so SIT reports also be placed on record before the. Please try to file these 1-2 days. I know this is you always do this. It's all MS only's fault, I think.
My lord.
She always does is a strategy.
No, my lord.
To take us to ambush us, and just before the court sits to the reports to be brought. Maybe we might have to appoint an amicus. Anyway, we'll see. Yes.
Yes.
Thank you. 28th. On that day also we'll make over the 37th interim report. Yes.
Yes.